Good morning. Welcome to your hopefully third day of the conference. I know some people arrived a little later due to some weather delays, but I'm glad that you're here now. And thank you for being here bright and early on Pacific time. I'm still on East Coast time, so it's mid-morning for me. I'm good. Before we get started, I do have a few announcements to let you know about. First of all, the session is being presented again today at 1:15 to 2:30 in room D2. And also on Friday morning, again bright and early at 8:30, the first session of the last day of the conference. If you like the session, please tell your friends. Like your Uber driver, we would love to have your 5-star rating. If we do not deserve your 5-star rating, my name is on the front of these slides. Please email me and let me know. You also have the opportunity to evaluate this session as well as the entire conference. So that can be done on your mobile phone. If you do not complete it on your mobile phone or through the app, they will send you an email. I believe just one, so we won't pester you to death, but they will send you an email giving you a link so that you can evaluate, again, this session as well as the entire conference. For this session, we will allow time for questions at the end. There are 4 microphones in the aisles, and we will make sure that everybody can hear your question. If, however, you do not prefer for everyone to hear your question, or given that the session may be recorded, you wish not to have your question broadcasted, you may certainly ask me afterwards if there is time. If not, you can certainly email me. Again, my name is on the slides. Anybody at the department has the same email format, which is firstname.lastname@ed.gov. So you're welcome to email me if you have questions later, or again, you just don't wish to ask them in front of all of your colleagues. My name is Anne Marie Weissman. I am the director of the Policy Development Group. I have been that now for 10 days. Yes, 10 days. So prior to that, I was the director of the Policy Coordination Group. So it is not a big change. My focus is changing slightly from predominantly loan issues to the general provisions and FSA issues and other kind of more general topics. So prior to that, I also was with the department in a couple of other roles. I was a training manager, a training officer, and I started out back in 2007 in program compliance. So I was the person that nobody wanted to see on their campus coming up for a program review or doing audit resolution. But again, after that, I switched over to training where I was the person everybody wanted to see. Now I'm somewhere in between. But again, happy to be here, happy to have worked on several regulatory packages now, one of which was borrower defense, which we've now done twice. I have a little visual aid. These are our regs. This is what we're talking about this morning. I have a nice bound copy because I'm that much of a geek. Our NPRM went out in June of 2019, and it had 89 pages, about. The final rule came out on November 1st, and had about 145 pages. Now that doesn't sound like too much, right? But remember, we're talking the Federal Register pages. 3 columns, tiny font, lots for you to read. So again, hopefully we can demystify some of borrower defense for you today. We'll start with a disclaimer. We wanted to remind you that the PowerPoint and the presentation are not legal advice. I am not a lawyer, nor do I play one on TV. You could think of me as your non-attorney spokesperson. We want to remind you that it's informational. We want to remind you that you can't rely on the information to make decisions with legal implications, but you should consult your legal counsel at your institution, your risk management office, or contact me through the department at the Office of Post-Secondary Education. And again, we'll be happy to answer your questions. Giving you an overview of where we plan to go today, we'll first look at timelines. We'll look at the federal standard and the evidentiary standard, notice and process requirements, who does what in terms of paperwork. We'll look at the difference between affirmative and defensive claims and why that matters to you. We'll look at the limitations period, the definition of misrepresentation, financial harm. We'll talk about arbitration, closed school discharges, false certification, and some items about financial responsibility. So it's quite a lot to talk about. My mother has told me I'm known for making a short story long. However, I will try to leave that time for questions at the end. We use some abbreviations in the presentation. Many of these are abbreviations that you're familiar with. However, there are a couple I do want to point out. People may not be familiar with the Financial Accounting Standards Board, or FASB. If you are not an accountant, again, I'm not an accountant either. I see a couple out there, so I know you're here. You may be able to talk about FASB standards with me. Also, property, plant, and equipment, PP&E, is another abbreviation that is more used in the accounting world, and you may, as a financial aid administrator, be less familiar with that. We wanted to start off by reminding you about negotiated rulemaking. We have a lot of information that goes into what made these regulations, and we wanted to make sure you had access to all of that information, so we've consolidated it onto our website. It is a very long link if I gave you the direct link, so I find it easier just to go to the ed.gov website and then search on rulemaking. There are multiple years of rulemaking out there, so if you want to look at other ones, that's fine too. But if you'd like to take a deeper dive on borrower defense, you can find that under the 2017-2018 rulemaking. There is also information if you want to compare the prior rulemaking on borrower defense as well. Pretty much all of the documents that went into preparing NEG-REG in advance, as well as during the sessions, any session documents that people presented during the session and the negotiations are out there, whether from the department or external parties. So again, if you're looking for some of the history and the background of how we got to where we got, you're welcome to take that look. All of the links to the Federal Register notices are there as well, links to where you can find public comments and other information. Talking now about timelines, a lot of people are saying that they're confused about what applies when. The timelines are something that are really important because it determines what standard is used. It determines what set of regulations we will use to adjudicate that claim. So the first, I think of it as buckets, and the first bucket or the first box on the screen is the pre-2016 regulations. We really don't have a lot of regulations there. We actually talked about negotiating, and when we got the panel together for that and some other topics, the negotiators felt that it was not something that we needed to go into deep information about, that there would be very few of these claims. So they declined to negotiate on that topic. Now fast forward to 2016, we published a rule based on negotiating that we did in 2017. I was at the table for those negotiations. It was a very interesting time. We had some large school closures that led people to believe that we would have large numbers of claims. And so the negotiating committee felt very strongly that we needed to have detailed information about borrower defense in regulation. We had some changes. We had people look at the regulations that we had and felt that maybe there were some things we could have done better. We did not reach consensus in the first negotiated rulemaking on borrower defense, so it made sense to go back and look at feedback we heard from the community and information that we had at the department that led us to believe that there could be some changes to improve the process. So that leads us to having that second bucket, which again are first disbursement date as your trigger. So the pre-2016 regulations, or again, very few, they are for loans first disbursed prior to July 1st, 2017. So when you look at these buckets and you think, well, then the next set from the 2016 rule means loans first disbursed on or after July 1, 2017, but before July 1, 2020, when the 2019 rule becomes effective. What that means is that you could have a borrower with multiple loans that would fall into multiple buckets. So you'll want to be aware of that. (685-206D) is one of the locations for regulations for borrower defense, and the other citation that you'll want to look at is 34 CFR 685-222. It would be very difficult, as many people said, why not just go back and say that everybody is subject to one set of regulations, and that would streamline it for the borrower. And while it would streamline it for the borrower, it would be very difficult to administer. Remember that with regulations, we tend not to go backward in time. we tend to go forward only. So we have the master calendar requirement that's in the Higher Education Act. That basically says that you must publish regulations on or before November 1st of a given year so that they're effective on July 1st the following year. Now, the master calendar requirement was put in for a very specific reason, and that is based on information from people like you, people like software vendors and others. This has been in place for many years, but the point of it really is so that you have time to get to learn the new regulations and understand how they apply. It gives us time to get out and educate the public about what they mean. And so generally it's seen as a very good thing. But again, here it can seem confusing for people in that there are 3 sets of regulations, and in theory, a student could fall into all 3 of those. But we think it's very important to make sure that all of those information sources are out there, that information goes to not only the borrowers but the institutions, and we want to make sure that we're not changing the terms of loans that students have already agreed to receive. So the student signs a master promissory note and information applies to that time period. They get disclosures that apply to that loan. So we want to make sure that we're clear about why there are the 3 buckets. We talk about having a federal standard in both sets of regulations. Now, the 2016 standard was an act or omission of the school attended by the student that relates to the making of a direct loan for the enrollment at the school or the provision of educational services for which the loan was provided. That's pretty straightforward in terms of what we're looking at. The basis for the claims in 2016 were a judgment against the school, breach of contract, or substantial misrepresentation. When we're looking at the difference between the 2 standards, in 685-206E, we look at the federal standard in 2019, and I want you to try to compare and contrast kind of with what we just talked about for the previous ones. The institution at which the borrower enrolled made a misrepresentation of a material fact upon which the borrower reasonably relied in deciding to obtain a direct loan or a loan repaid by a direct consolidation loan, and that directly and clearly relates to enrollment or continuing enrollment at the institution or the provision of educational services for which the loan was made, and the borrower was financially harmed by the misrepresentation. So you might say, well, this isn't that different, it's just a little longer. Well, it has some key points in there, and I think that they're really important to discuss. First of all, we want to think about the idea of misrepresentation as something that pertains to things that are not just material fact, but the number of things like lockers in a locker room would not be substantial misrepresentation. The idea of the hours of the library being cut back by a couple of hours a day, that's not a substantial misrepresentation that directly relates to the institution's educational services or the program of study that the student is in. We were looking for things not like a slip and fall on a sidewalk. We're looking for things directly about the institution's programs and the institution itself. So think of it as an area where we define terms. Think of it as looking at things that the accreditation group or the state authorizing agency would be reviewing, things about your programs. I think that it's really important to think about what all resources are on your campus and think about those direct educationally related items. So it would have to relate to that program of study. It would have to relate to things like placement rates are an example, things like graduation rates, retention rates, very specific concrete things. One example that we talked about around the table was the idea of somebody needing a certain standard to remain in their accreditation. So if the standard is you need an 80% pass rate on a licensure exam for your students, and let's say you get a cohort of students that is 70%, someone could argue that, well, that affects their program of study, and you want to look at the idea of, are you misrepresenting something because you want to make sure you remain accredited? That does relate to the student's program of study. Generally speaking, there are mistakes that can be made. This isn't so much about mistakes. This is misrepresentation. This is knowing something is incorrect and providing it to the student. So to try to simplify the idea of what this federal standard means in these regulations, we look again at that misrepresentation of a material fact, the borrower reasonably relied on the information presented, and that it directly and clearly relates to either enrollment or continuing enrollment at the institution and that provision of educational services. The borrower then must also suffer financial harm as a result of that misrepresentation. So there could be times that there was misrepresentation but no harm. That means there would be no relief for the student. I think that's a really important concept because that was not something that we emphasized in the first set of regulations, but it's important to note that we are not trying to go out and say the student should be able to claim harm where there isn't harm. We will evaluate the application and determine if we find harm to exist. Looking at the evidentiary standard, I want to highlight here that many people expect a lot of changes from 2016 to the 2018-19 regulations. We talked about some more substantial changes at the table. We also put some out in the NPRM. And this is probably one of the biggest differences between what we put in the NPRM and what we published in final regulations. So we have the standard preponderance of the evidence. Now, I've already told you I'm not an attorney, but I understand the concept because it is fairly simple. Preponderance of the evidence is very different than what we put out, which was clear and convincing in the NPRM. We heard significant feedback from members of the public that that would be very difficult, and that what we were doing was essentially saying that no one would ever be able to have a successful claim. That was not our intent. So we changed in the final regulations that standard back to preponderance of the evidence. So that again, there is now no change in that evidentiary standard for the 2016 and 2019 rules. On this slide, we've kind of summarized it for you in a nutshell. It's, again, fairly simple even for a non-attorney, more likely than not. So that means the student is presenting information and the institution doesn't have anything to the contrary. That means more likely than not what they're alleging actually occurred. So that means greater than 50%. We want to highlight the idea of how the information exchange happens. So borrowers have one process and institutions have another. We want to make clear that it's important that we have information from both sources. We are not making a determination solely based on what the student provides. Institutions will have an opportunity to respond. But first we'll talk about the borrowers. The borrowers need to sign an application under penalty of perjury and also sign a waiver. That waiver gives the student information over to the institution. It's them releasing that information, saying it is okay for us to share what they've sent to us with you. The student also has the opportunity to provide evidence with their application, and they will be asked to state the amount of financial harm that they believe they have suffered. They will also be given an opportunity after the institution responds to reply to that response if one is provided. So I want to go back to that idea of stating the amount of financial harm. Remember that the department will also be looking at what that harm is based on the information that is provided in the application, the information from the institution, and potentially information that we already have in our possession. The institutions, as I mentioned, are notified that an application has come in for that institution. They're provided with the borrower defense application that the student submitted, and then they're given a formal opportunity to respond. One of the things that we heard is that that is a very key point for institutions. Around the table when we talked about this in both years, it was very important and it was very clear to us that institutions were concerned that they would not have a chance to provide evidence, to provide information to the contrary, and so we want to make very clear that you do have that opportunity. Now, as I mentioned earlier, we do not have a group process for borrowers to submit applications, or we will not allow others to submit a group on their behalf. They will have to do an individual application. So institutions do not have to worry that they are going to get flooded with applications at one time from a group of borrowers. They will apply individually, and one of the reasons for that is that we want to allow them an opportunity to provide that evidence individually and to make sure that they've stated the amount of harm. And so again, we think that's really important for institutions to understand how that process will work. I want to talk just for a minute about the types of claims and the limitations period. In terms of the types of claims, we talked about the idea of affirmative versus defensive claims. And that was a concept that we talked about in the NPRM, or the Notice of Proposed Rulemaking. It got a lot of discussion. It received a lot of public comments. And so by the end, we decided that we would look at affirmative and defensive claims. We would not restrict ourselves to just one type. The limitations period in the 2016 regulations became very complicated. Some of it had to do with this idea of affirmative and defensive claims. If you had an affirmative claim, and that meant that you were in repayment or in the grace period, for example, even still in school, that was an affirmative claim. A defensive claim was if you were already in default. There were different standards in terms of how much time you had to submit a claim based on the type of claim you were submitting. That got very complicated. It's very difficult for borrowers and for institutions to know. Institutions would say, sometimes we didn't know somebody was in default, and we don't know what the limitations period would be. We've simplified this for 2019, and I think that's very helpful. It is 3 years from the date that the student is no longer enrolled. No longer enrolled could mean that they graduated, that they withdrew. Whatever reason they left your institution, they have a 3-year window with which to apply. Again, we think with reducing regulatory burden, that is very helpful. Again, it also increases the understanding for a borrower. They no longer have to try to figure out, can I apply, can I not apply? They know 3 years from that date. Keep in mind that the Secretary has the flexibility to extend that time period. It is a may, not a must, so the Secretary may extend the time period, but the Secretary is never required to do that. We think that's important as well. We want to allow for special circumstances. We also want to remind you of the idea of what told means. Told is a pause. And so for certain situations, we can pause. And in that case, again, we're trying to provide for some flexibility, but in that case, we would not require the Secretary to exercise that flexibility. It would already exist within the regulations. And a couple of the reasons that something could be put on pause would be if there were arbitration proceedings already going on with the situation, with that specific case, or if there's a court judgment that satisfies the definition of misrepresentation. We'll talk a little bit later about what happens if a student is going through another proceeding and receives money. But first, we want to remind you of this definition of misrepresentation that is contained within 685-206. The other thing I do want to point out first is that remember when we talk about Part 685, those are the direct loan regulations. So this is not pertaining to FFEL loans, this is direct loans only. I'm going to read to you the definition of misrepresentation just because it is so very specific. I generally don't like to read slides, but I think some of these are very important because of the detail and the nuances. Our definition of misrepresentation in the 2018-19 regulations is a statement, act, or omission by an eligible school to a borrower that is false, misleading, or deceptive, made with knowledge of its false, misleading, or deceptive nature, or with a reckless disregard for the truth that directly and clearly relates to enrollment or continuing enrollment at the institution or the provision of educational services for which the loan was made. Now, I want to break those down a little bit because there's a lot of key concepts in there. We want to first point out that intent is not a requirement. So it doesn't have to be that a school intended to do something to be misrepresentation, but it does have to rise to an important level. So first I want to highlight the idea of a statement, act, or omission. So it can be something that you didn't say, that you knew to be correct, that you did not say to the borrower. But also it could be an outright statement or an act. That's important because people struggled with the idea of an omission, and so we do want to highlight that that is in the final regulations. Some of that could be if a student asks for information and you don't provide it, but you did have it, if you say that you did not have access to it. One example of that might be placement rates on a national exam required for licensure. We're talking about some statement that is false, misleading, or deceptive with knowledge of its false, misleading, or deceptive nature. So again, we're talking about pretty serious offenses. People often worry about borrower defense claims that there will be frivolous complaints or that everybody will rush to complain about something and the department will say, well, okay. We're talking about pretty intense situations here. False, misleading, or deceptive. You know, who in the audience says, oh yeah, I strive to provide false, misleading, or deceptive information? No one. You're generally trying to do the right thing. We also talk here about a reckless disregard for the truth. Generally speaking, that's not something you do accidentally. So I think it's important to put it into context. And then again, those two key concepts of what it relates to. So we're not talking about reduced hours in the library by a couple of hours. We're talking about something very, very specific. And again, not slip and fall situations, not campus security issues. We're talking about something that is enrollment or continuing enrollment at the institution level, or essentially a provision of services for which the loan was made, which can include things like program of study. If you tell them that a program of study allows them to sit for licensure in their state, and then you know that it did not, that could be a borrower defense claim. But again, I think for the most part, the people in the audience sitting here are the ones who want to do it right. So I hear people worrying about the idea of claims, and I do think that if you're doing the responsible thing and you're doing your best, it is not something that you have to spend nights up and awake worrying about. Misrepresentation examples, again, are really important. I want to put it into some context because people often will say, well, what about this? What about this? And this gives us an example. What I'll say is the best word on this slide is example. There are 5 words in the English language that when strung together, I dislike the most. And those are including, but not limited to. If I say including, of course I mean but not limited to. I'm giving you examples. So I just want to highlight that these are examples. This is not an exhaustive list, which are another few words that I'm not crazy about. But again, I think you know that. I just want to make sure I do highlight it in case you weren't clear. These are just examples. So actual licensure passage rate I just mentioned, actual employment rates. If you have data back from your students, your graduates about jobs that they've attended or received from attending your institution, if you have actual rates and you provide them with another rate trying to get them to enroll, that's a misrepresentation. There are magazines that produce information about rankings, selectivity kinds of issues. You want to say, well, we're in the top 10 for this category or for this program or the top 10 most affordable institution. If you know that's not true, you should not be saying that to your students at entrance time. Again, I mentioned the idea of saying that something at your program, that a program of study would allow them to sit for licensure. If you know that your state requires certain things and your program does not provide it, that would be a misrepresentation example. Another example of that is if you say a program is endorsed by someone or that you have accreditation for the program and you do not have it for that program, that would be a substantial misrepresentation. Transfer of credits. If you tell them that their credits will transfer to several local institutions and you name them, but you know that you've had students come back to you and say, they won't take my credits for this program, that would be an example of misrepresentation. Earnings amounts as well as placement, the amount, availability, or nature of financial assistance is one we get a lot of questions about. We got a lot of questions about this after the last negotiations and the one before that. We had people at the table who were concerned that what we meant by that was if you made a change, that could be a problem. We are not talking about changes in awards. If you provide the student with an information about a change, that's not a misrepresentation. Keep in mind that there are many reasons that a student's award could change. People were worried that a state would give them a grant amount on a letter and then reduce that amount because of budget cuts, and that we would hold them accountable for that change. We would not. That is not where we're going with this. We're talking about someone who says, for example, you have a scholarship for 4 years of attending our institution, and you know that that scholarship may not be available, that they have to renew it, that they have to have a certain grade point average, but you fail to mention any of that to the student. You say to them, because you want them to enroll, you have a scholarship here for 4 years. That could be a misrepresentation. You want to make clear to them that the scholarship has to be renewed, that they have to meet certain GPA requirements, that they have to take a certain number of credits. If you're doing those kinds of things, which I believe you are anyway, you're notifying them through the old-fashioned award letter or the more modern portal, however you notify them. That's fine. You want to keep a record of those notifications so that if a student later says, they didn't tell me, you can say, yes, we did. We sent you information about the revised award. We've also said when asked that if a student receives the information through a school portal, that is considered delivered to that student. We don't require a process in place that you can say that they've read the information or that they acknowledge the information. Sending it through your portal is adequate notification. It's kind of like the idea of when you send something through US mail, which I know we do a lot less of these days, but if you send it through the mail, you can assume it's been received. We also want to remind you it's the amount, method, or timing of the actual tuition and fees. This, I probably would guess it happens more at clock hour institutions than credit, but it could happen at either. If you tell a student that they are going to be billed for a program in increments, but then you charge them all of the tuition and fees up front, for example, that would be a substantial misrepresentation, and it would be very difficult for some students to have enough funding to cover that. So you want to make sure you're clear with them about how your tuition and fee structure works and when they would be expected to be billed. Again, we talked earlier about endorsements, the educational resources provided, and prerequisites for enrollment. So if you tell a student there are no prerequisites for entry for a specific course in their major or in their program of study, and then later you tell them that you've added prerequisites, kind of like our regulations with loans, we say we go forward only. We would expect that you wouldn't then retroactively apply prerequisites to a student. We would expect you to give notice if you were saying, as of this date, it would be effective. You will need these prerequisites. So again, it's notifying students, informing them of decisions that affect their program. I believe that most of you are doing that anyway. So again, not as much of a concern as you might think. Switching to talk now about financial harm. There is a definition of financial harm that we have for you on the screen. It's the amount of monetary loss that the borrower incurs as a consequence of a misrepresentation. So again, it has to be a misrepresentation first, and then there has to be some harm to the borrower. So by harm, we mean monetary loss. Now, at the first borrower defense negotiations, a lot of people were talking about opportunity cost. We're not talking about opportunity costs. The idea that a borrower finished a program 6 months later than they were originally thinking they would, well, they have a loss of income perhaps for 6 months. That's an opportunity cost. Something that affects their tuition and fees, if you tell them that the tuition and fees for attending their program would be $12,000 for their certificate, and it turns out to be $22,000, that's a problem. That's a big difference of $10,000. So that's something where there might be monetary loss to the student. The student, again, on their application form would indicate the amount of financial harm that they believe they suffered. They might have various reasons or various ways to calculate that. The department will examine those, and again, we'll examine those based on the information that the student provides, as well as information the institution provides, as well as information that the department may have in its possession that we may use. And again, people often ask, well, what might that information be? That could be that we've done a program review at the institution 2 years ago, and we have information about a finding that occurred, and it covers the period of enrollment that the student is alleging the misrepresentation occurred. So we're looking at information already in our records. The department, as I said, will then determine the amount of harm that we believe the student suffered. We understand that the amount could exceed what the student believes the harm was, because again, we may have information that the student and the institution did not provide, but is that information that we already possessed. I also want to remind you that in both sets of regulation, again, trying to draw those parallels, there was no difference in the idea that we allowed for partial relief. There were a lot of people that were very confused about that, and they said, well, in the first set of regs, you only had full relief, and in the second set, now you're limiting students to partial relief. And that's not the case. Both the 2016 and the 2019 regulations allowed for partial relief. We didn't ever get to the specifics of how that partial relief would be calculated within regulation. Think of it this way, regulations are more high level. The same with statutory issues, they're high level. Things that are procedural, we generally do not regulate. We're often famous for saying the secretary does not regulate herself. We do not put actions that the secretary has to do and timelines in our regulations very often. The reason for that is we do want to build in some flexibility depending on specific situations that occur. We want to make sure if we have large numbers of claims, we have the time to process them and that we're giving them the individual attention they need. We also want to develop systems in our department about how we will look at that partial relief. So again, no difference there between the two sets of regulations. The regulations were high level and just explained that partial relief was possible. Keep in mind, though, that the relief in the 2019 regulations is limited in one way that they were not in the 2016 regulations. We say that the relief cannot exceed the amount of the loan and any associated costs and fees. So think about origination fees of the loan. We're talking about the full amount of the loan that the student obtained. The piece here that I think is really key is the idea of the amount of the loan. There were many people, again, who argued at the first negotiations that we had on this topic that we should consider opportunity costs, that the student might have paid for childcare during the time that they were enrolled and that we should reimburse them for those amounts. Other things that we would generally not consider, although they might be part of the cost of attendance, we are saying it's limited to the amount of the loan. Look at the title for these regulations on the top of the slide. It says Part 685.206. Those are the direct loan regulations, as I mentioned earlier. That is a key point. It may seem minor, but it is very, very important. We're talking about the amount of loan that the student received. These are borrower defense to repayment. Repayment of what? Repayment of their direct loan. So we're not talking about Pell Grants. We're not talking about work study amounts. We're not talking about amounts that they paid out of pocket. We are talking very specifically about the direct loan program. And so that is the amount that they received in that program. To me, that is one of the most important things to remember in this set of regulations. So we're not looking at opportunity cost. We recognize they may exist. However, the student may have other avenues of resources or of recourse that they can consider for those resources. So we want to make that point as well. And we'll talk about that a little bit more in a minute. Another item that has changed in the regulations from 2016 is the treatment of pre-dispute arbitration agreements and class action waivers. In the 2016 rule, these were both prohibited. You were banned from using either of those on your campuses. There were many institutions at that time who were using them who then had to kind of backtrack, even though it was in their enrollment agreement, and change enrollment agreements and kind of scramble to do a lot of change at their institution and explanation and education to their students about what that meant. Fast forward to 2018-19, there was a court case, there were other ways of looking at it, and we decided that we would allow the usage of it, both the pre-dispute arbitration and the class action waivers. However, the institution would be required to make disclosures to students, and we added that in the general provisions regulations out in 668.41. We wanted to keep all of the disclosures together. So we then said, if you were going to use this, you need to notify your students. And I think that's an important concept again. It gives the institutions flexibility, but it also notifies students. So they understand what that means. They understand how it impacts their potential case. The limitations period, again, as I mentioned earlier, would be told or paused for any period for which those arbitration processes are occurring. That's also another, in my opinion, very important idea to remember, and that the students may not necessarily understand at the beginning. We will try to educate them about how that process works, but we do know that sometimes students are confused by those types of things, and we want to make sure you're aware of how they work, as the student could, in theory, ask you these questions as well. Remember that you may be going through that as part of that arbitration discussion if you choose to use arbitration. Shifting now away from specific borrower defense issues to some of the other topics that we regulated in this package. I like to think of this kind of as regulatory potpourri. These are topics that are very much related, but yet somewhat separate from true borrower defense. So you'll see that here we're still talking about the direct loan regulations, but it's in another section. This is 685.214. We talk here about some changes that we made from 2016. In the 2018-19 regulations, we have expanded the opportunity for students to receive a closed school discharge. The previous window was 120 days. It will now be 180 days, and that's the look-back period. So if the student was enrolled at the institution within, it will be 180 days, or approximately 6 months, from the time that the institution closed, they would be eligible potentially for a closed school discharge. And when I say potentially, that's because the student has the option of taking a teach out if one is available. The student also has the option to transfer their credits to another institution, which essentially means that a formal teach out wasn't available to them. So either of those are options that the student may choose. We would say that the student always has that choice. It's not the institution determining which, it is the institution providing the information to the student and explaining to the student what their options are, whether it's teach out, transfer, closed school discharge. Of course, if there is no opportunity for a teach out, many of the students would claim the closed school discharge. We wanted to make it a little bit easier to obtain the discharges for students whose schools have closed, in that what we were finding is a lot of borrowers were thinking then they would do the borrower defense to repayment application if their school had closed and they were outside of that 120-day window. What this does is it streamlines the process for both them and for you. So it means a longer window, but hopefully it means a more expedited process for both the student and the institution. So we're giving them an additional 30 days. People often ask, well, why 180 days? We thought that 180 days was really a useful amount of time because that at a standard term institution would be about a semester and possibly a summer. We also wanted to look at the idea of how applications would come into the department. As with the borrower defense to repayment, here there is no group discharge. The borrower would be required to submit an application. That has always been how the regulations read, and so we brought to this a different interpretation and believe that that means the student truly must submit an application. And again, that is under penalty of perjury. There are the standard disclosures on that form that the borrower would be signing. Remember, the borrower can choose, as I mentioned just a minute ago, between the idea of obtaining the closed school discharge or the teach out. Now here's the wrinkle to that. Here's the change or the update for 2019. If a school offers the teach out, the student can still choose the closed school discharge. We want to make sure that everybody is aware that that choice is still out there. However, what's a little different is once that student says, I want the teach out, I'm going to take the teach out, they don't get to later then come back and say, well, I want the closed school discharge. They're choosing one or the other. And I think institutions were really happy to see that change because, again, it makes it very clear for them what the student's intent is, what they're planning to do. Now, what we've often said when students ask is, they'll sometimes ask the department, well, should I take the closed school discharge? Should I take the teach out? We believe that we want to strengthen teach outs. And when I talk later today about the accreditation regulations that we've just implemented, yes, that's a commercial, we want to make clear that teach outs should be strong. They should be appropriate to the institution and the place where the student would attend later for their next institution to complete their program of study. What is the goal of education, and what is the goal of the student obtaining an education at any institution? The goal is to complete the academic program of study. We want them to be completers. We want them to be graduates, and we want them to go out and become good taxpayers and earn an income that will support them and their families. So we want good things for them. In many cases, completing your academic program, even if it's not at the institution that you originally selected, completing that program is really helpful to the student, especially if they're really near the end of their program. We want them to complete their education within a close approximation of when they would originally complete. So we encourage teach-outs, and we encourage, again, strong teach-outs. We want teach-outs that are really helpful to the student, that would be as close to their program of study as they originally had. We want them to have good opportunities. So we would want them to want the teach-out. But again, we always allow for that student to make a choice to obtain the closed school discharge. With this 180-day look-back period, we still allow for the secretary to make exceptions. If there is information that the department has that says there were problems at the institution much longer than 180 days, we could extend that. The secretary could make the decision to extend the look-back period. But again, here we're talking about exceptional circumstances. I'll move now to false certification. The false certification discharge has been in place for many years. Again, that regulatory citation is 685.215, not a new regulatory citation if you've ever looked at false certification discharge. Once again, we're requiring the borrower to submit an application to the department, and again, signing the standard under penalty of perjury, I am telling the truth. We want accurate information from the borrower. We want any evidence that they have to provide with it. If a school certified eligibility, but the borrower was not a high school graduate or otherwise qualified, the student could potentially qualify for a false certification discharge. So we're typically here looking at high school information. If the borrower, however, submitted written information in an attestation to the school because they said they were unable to obtain a copy of their high school diploma. We hear that a lot from students who say, my school closed many years ago, my high school records were supposed to be held by the state or by the local school district. They say they don't have one. Sometimes the school will, or the state or the local agency will send them a letter. Sometimes it is a student literally sending you a signed statement saying, I tried, but I cannot obtain a copy of my high school diploma. However, I am a high school graduate. They are then certifying that. That is a signed statement. You can then rely on that signed statement. So we want to make clear here that if the student uses that option at the time of admissions, you then are not on the hook for a financial liability. You don't have to pay out financial false certification discharges. The student would not be eligible based on the information that you would provide to the department, which likely would be a copy of that signed statement. That is also a slight change from 2016, where we just did not make that distinction. That doesn't mean that we wouldn't have necessarily come to the same conclusion, but we did not state it within the regulations. Now on to financial responsibility. Financial responsibility has kind of a couple of pieces here. We're going to talk first about the idea of triggers. There were triggers in the first borrower defense set of regulations, and the 2019 regulations are no different. There are some triggers here that are mandatory, and then others that are discretionary. The department would look at mandatory triggers and then determine how they were going to cover for that potential loss. Typically, that is in the form of surety. Typically, when we talk about surety, we're talking about a letter of credit. So I'll pause for a minute and tell you that we are here trying to be more flexible. We are trying to open up to potential changes within the idea of surety. Right now, the letter of credit, we say, has to be irrevocable. You as an institution supply it to the department. The department can release you from that letter of credit early, but you as an institution cannot say, we want to retract that letter of credit. Unless, of course, you're providing another one from a different institution for the same amount, and there is no date that it would lapse in the middle. So generally, you're supplying an irrevocable letter of credit. Some institutions have asked for other ways that we can obtain surety. And so these regulations make it clear that that would be possible. It's kind of like when we say on a form approved by the secretary. Here we're saying as a method approved by the secretary. So we're kind of putting out there a possibility for things that don't necessarily exist today. At the department, we talked a couple of years ago with people who had bond products who said, we think this might be a way to provide surety as opposed to a letter of credit. At the time, however, the companies were not able to provide products that were irrevocable. However, there could be a day that they come up with a product that is. We want to make it clear that we don't have to go back and re-regulate to allow for that kind of product. I think that's a great sign that we are being more forward-thinking. We are trying to think in a way that is more positive about how we could go forward without having to re-regulate everything that's out there. We want to be able to allow for situations that we can't necessarily predict now, and I think that's a bit of a change from where we were years ago when we would wait for something to happen and often kind of be the latest people to adopt it. We are trying to be more forward-thinking and allow for different possibilities. The other possibility that this allows for now, or when they become effective in 2020, is the idea of offset. The offset idea is, in my opinion, a really nice option that is an alternative to a letter of credit. As many of you know, back in around 2008, 2009, the country hit very hard times. We were in a recession. And in that time of a recession, we noticed that institutions were telling us the idea of obtaining a letter of credit has gotten much more difficult. We thought that that might change after the recession ended, and what we're hearing from you is it has not, and that obtaining a letter of credit is very expensive, sometimes difficult to get. Sometimes the time period that we were allowing for you to obtain the letter of credit was not enough for you to do it. The bank wanted more information from you. You felt squeezed because we were saying you have 30 days to provide us with this information, and you couldn't necessarily get it. The offset idea is an alternative to the letter of credit in that we would hold back a portion of your disbursements. Now, some people say, oh, I would never want to do that. Other people say, that's great. That would allow me the option that I don't have. It would allow me to do it over time. Think of it almost as a financing plan. You're kind of financing your letter of credit or your surety. It's not for everyone. I won't say it's the ultimate way of doing it, but it is an option to you. And again, I think we're showing that we're trying to be more flexible and we're trying to work with you and provide you something that was not there previously. So to me, it's a really positive change, and I hope that you agree. In terms of mandatory triggers, we're looking at things like settlements or final judgments, final determination on a case. Withdrawal of owner's equity could be a trigger. Publicly traded institution has other institutional triggers. We also note that two of these mandatory triggers would equal, two of the discretionary triggers, which I'll talk about next, would equal one mandatory trigger. So the discretionary triggers include actions from your accrediting agency. One example of that would be a show cause. However, we do know that accrediting agencies use different terminology, and so there might be other terms that they use that we see of as the equivalent to a show cause. So we're not looking so much for specific terminology here, but we're looking for what the consequences would be if the action were taken by the accreditation agency. We're looking at things that are much more serious. We're looking for things that could result in you losing your accreditation. So we're looking at things that, in our opinion, could yield future borrower defense claims. We're also looking at violations of loans, violations of standards or requirements of your state licensing or your state authorizing agency. Again, with that, we're not looking at every little violation, but we're looking at things that could potentially jeopardize your authorization with that state or your ability to be licensed or operate in the state. That could, of course, yield closure. That could mean a lot of closed school discharges or potentially borrower defense to repayment claims, and we'd like to try to prevent that. But by being discretionary, we're not automatically taking action when one of this list occurs. We are looking at it. We are considering any special or unique circumstances. We are realizing that something could change in the future. And if you tell us, well, we have a corrective action plan to address that situation, and the state, for example, has accepted it, we can then make a determination of what we want to do and how we want to proceed. Failure for 90/10 is kind of another trigger there. Also high annual dropout rates and recent cohort default rate outcomes. So if your cohort default rate changes significantly, or if it meets the threshold for potential problems for you, again, to lose your eligibility for Title IV aid, we want to take a look. So I think it's important with this idea of taking a look. The discretionary triggers, again, can become mandatory if you have two or more. However, if you have one, that gives you the opportunity to provide information to the department. You always have information that you can provide to the department, but this may mean that there then is no action as a result of it. And I think that's really important to note because, again, it's showing that we're trying to work with you. It's putting into regulation some flexibility to remind you that you have an opportunity to provide information to us and that we will consider that information. Also related to financial responsibility, as I mentioned earlier, the idea of offsets. I think this is a really great change, even if you never use it. It's showing, again, that we're kind of showing our goodwill and that we're giving you options. I always like options. That's kind of a family trait. My daughter is very big on negotiating everything. And so, like many children, she wants options all the time, and I was kind of the same way. Options to me are good. It doesn't mean I ever have to take advantage of them, but I like knowing they're there. If something comes up and you can't obtain a letter of credit, this is kind of your backup plan. We also eliminated the 45-day deadlines and increased that based on estimated losses. So the deadlines, I think, are key, again, because we recognize sometimes it takes you more time to get information that you need, and we want to make sure we're giving you reasonable amounts of time to submit what you need. Also, we've updated the ratios slightly. Now, this is where I pause and again remind you I am not an accountant. I do not play one on TV. I know there are accountants in the audience, and they probably can speak to the FASB changes much better than I can. I will do my best, however. FASB, remember, is the Financial Accounting Standards Board. They have made some updates over the course of many years that we have not adopted because we have not regulated financial responsibility again. We know that members of the community have asked for that many, many times, and it's something I would say the department is seriously taking a look at and we would like to do. However, in the middle period of time there, we've got to do something. We are at the point now where there have been so many FASB changes that we felt we needed to update our ratios, but we didn't want to re-regulate the entire package or the entire way of calculating ratios. So what we did was we had a subcommittee within the borrower defense to repayment regulations. That subcommittee was made up of people who had far more accounting knowledge than I did. So the subcommittee went, they talked among themselves, they came up with some ideas for how we could change our financial responsibility standards to kind of modernize and meet the FASB standards. I thought that was a great way of handling it. Remember, this was a subcommittee, though, so the subcommittee did not have the authority to make changes. We did not vote on anything within that subcommittee. The subcommittee brought information back to the main committee that was regulating on the other topics, and they provided some really great information to us. And again, much of that information is out on our website if you'd like to refer to those documents. They were really helpful. We had amazing amounts of knowledge in the room. It was a small room. They were in there for a long time, working very hard for days in a row, but they really did accomplish their task. They found ways to help us update and modernize without having to re-regulate the entire financial responsibility items, and yet still then come into play with the FASB standards. So that was a great thing. So we made some updates there, but what we also heard from people around the table is that some of those changes would have significant impacts on certain types of institutions. We listened, we talked about that, we took that back, as we're like to say, and we made a decision that we would do some grandfathering in of a couple of provisions. Those provisions are leases and long-term debt. So again, with my limited knowledge of accounting, I will say that the idea of leases, the treatment of those within the accounting world changed. And so what it could mean was a lower financial score for institutions. We wanted to make sure, because some types of institutions, we heard especially from the cosmetology industry, that they tend to be in very long leases. They set up a school and they don't want to leave that location. They do a lot of work with things like plumbing to have large amounts of sinks, for example. They have electricity put in. They don't want to go to a new building every 2 years. So we looked at the idea of long-term leases. And what we said was we would grandfather in any existing lease, regardless of its length. That said, if you obtain a new lease, then you would be subject to the new FASB standards. We thought that was a fair way of doing it. That is one area, and I believe the only area, where we deviated from the subcommittee's recommendations. They recommended a time period, and I know we went back and forth. I believe they suggested 6 years. We talked about 8 at one point. I believe they recommended 6. And we decided we would not put a time limit on it, again, to be more flexible. So we're giving you this opportunity. We also grandfather in the idea of long-term debt, and we say that that requires a tie-in to property, plant, and equipment only for new long-term debt. So what that essentially means is the new FASB standards restricts long-term debt to specific uses, property, plant, and equipment. Previously, we said any long-term debt would be treated in a certain manner. So this is narrowing it based on the FASB changes, but again, we wanted to give people an opportunity to find out what the new regulations and the new standards meant and have time to adopt that. So I do think that here, again, we're trying to be more flexible. We're trying to be responsive to public comments, and we have people that I see here in the audience who were at NEGREG and around the table with us, and I think they will agree that we really tried hard to listen to all parties and come up with solutions that would work for everyone. I said I would allot some time for questions. I also did tell you I can make a short story long. In my defense, however, this really isn't a short story. There's a lot here. So I did leave some time for questions. If you have questions, I would ask that you proceed to the microphones, number 1, 2, 3, and 4. And we already have somebody at microphone number 3. Good morning.
Morning. Jeff Arthur with ECPI University.
If you could wait just 1 minute, Jeff. We are turning your microphone on right now. You're good to go.
Okay. Regarding closed school discharges, many institutions have multiple facilities, may have 3, 4 locations in a community, may offer over 50% of a program, so added that as a location on their e-car. Maybe you've got a facility in a community 60 miles away. Maybe expand a facility, consolidate. I mean, when you go in and put an end date on one of these facilities, is that a closed school? And you may have everybody taken care of, maybe they were able to transfer, but would your auto discharge system potentially look at somebody who dropped out, maybe 10 people dropped 30 days before that end date? Are they entitled to a discharge? Or would the system look at that as like, hey, here's somebody at a facility that closed, that attended within 90 days or 60 days and no longer attended? Is that somebody that may be eligible for a discharge and bill the institution?
I'm looking over at my sound person only because I'm having a hard time hearing the volume of your question, but I'll restate it as best I can in case the audience is having trouble as well. If I mischaracterize what you're saying, Jeff can just flag me down. Okay. So what I think I hear you saying is on the e-car, when you end a location, you are expected to put an end date, which is correct. My advice from when I used to do institutional eligibility has always been, and Jeff will be able to quote me on this because I've worked on some of his cases more than 10 years ago now, but we still remember. So I would always give the advice of do not close that out until all of your students have completed their program at that institution or at that location. If you have students that are still attending the location, you don't want to put an end date on it. You want to make sure they have finished. That said, having a location that closed is a closed location, and it could be interpreted as a closed school. That said, if you have other places that they can go, then it's kind of like offering your own teach out. So we know there are some schools that have locations in many areas. And if they're within a close proximity of each other, you can say, we are now offering your program over here. We would expect that that would be reasonable for a student to get to. So if you tell me it's 60 miles away, I would say that is not a reasonable commuting distance for an average student to get. If you tell me it's 6 miles away, it very well may be. We also look at things like what is in your area. We look to the states and the accreditors as partners in our triad to help us with this. Some accrediting agencies and some state authorizing agencies, usually accrediting agencies, have regulations about what constitutes a reasonable difference. So we would look at that as well. But generally speaking, we find that people who are closing a location are able to still continue teaching their own students. We do tell you that one option that you can do is allow people to take online courses. However, the one caveat there is if the original program of study was not online for that student, that is an option you can provide to them, but you cannot require that they take it. So it's an available solution for you, but maybe you're providing a location they can go to as well as the online option. As long as the student is making the choice to be an online student, that would be fine.
Yeah, I guess the big concern was the auto discharge process. If that could sweep some people into this where we've got to now explain that and so that that process doesn't go forward.
Correct. Microphone number 2.
Hello?
Yes.
Hi, I have a question about grandfathering of existing loans, the long-term loans and leases. What is the cutoff date for that? So if I have a long-term loan right now, will that be grandfathered, or is there a certain cutoff date?
So the regulations become effective on July 1, 2020. So from that period forward, these regulations apply. So long-term leases that you have in effect as of that date would be grandfathered in.
I think there's a disagreement up front. No?
I'm sorry, I can't hear you.
Thank you.
He's going to try to turn up the microphones. Good morning.
Good morning. I've got a question about the application determination when a student files an application to have their loan discharged based on borrower defense, and they allege certain facts that they claim amount to a misrepresentation. Will the department be issuing that determination of whether or not they agree that those facts existed and that there was a misrepresentation? Will that be in writing in some kind of a written decision issued to both the student and to the school? And will that ruling that you make be appealable internally at the department?
We are still working out some of the procedures for these regulations, so I can't totally answer your question, although I can answer the part about in writing. We will respond to the borrower and to the institution in writing with the outcome of their situation. How we handle it beyond that is still being worked out.
And will that written ruling be publicized in any way, like rulings from the Office of Hearings and Appeals are?
That is another detail that we have not worked out. I would not anticipate us publishing it per se. Keep in mind that our records would be subject to Freedom of Information Act requests, so they could be obtained by people, but I don't anticipate us publishing those. First of all, the information is private. That would contain information about the borrower. So keep in mind if it was subject to a FOIA request or Freedom of Information Act request, that we would have to redact information.
So there wouldn't be a precedent necessarily set by a ruling in one student's claim that could be used by another student in another claim?
In theory, a student could allege it, but we're not sending information out to people to try to encourage that.
All right, thank you.
Thank you. Back to microphone number 4.
I don't know that this, oh, there we go. All right.
Can we just turn her up a little bit?
Is that better? Can you hear me?
A little bit better. For some reason, I'm thinking it's because there aren't as many people in the room. We're getting a little bit of echo.
A lot of echo. I can hear it bouncing off the walls. My question has to do with the delay in the FASB standards for the leases. Is that affecting the implementation timeline for those rules?
So it's not affecting the implementation timeline here. We do talk sometimes about early implementation, and the secretary can designate certain items for early implementation. And I apologize, I don't remember right now if that was one of them. I believe it was.
Okay, so no impact because FASB is delaying certain parts of the lease provisions that there will have any effect on this particular
Correct.
implementation. Okay, thank you.
Thank you. I just got the warning sign that our time is just about up, so we'll take one more question at microphone number 3.
Oh, sorry. Okay.
That's okay.
Okay. You mentioned.
Can you pull that down just a tiny bit? I'm sorry.
Yeah, there we go. Better?
Yes.
The teach outs, you mentioned that as being an option for students for a closed school discharge. But are also teach-outs part of borrower defense? For example, if an institution just ends a program and offers a teach-out to a student for that particular program, even though the school is not closed, is that grounds, or could that be considered a misrepresentation for a student who wants to dispute something like that?
So I need a little more information, and maybe part of it is that I'm still struggling to hear you a little bit. You're talking about a teach-out when a program closes, so
Right.
not an entire institution, but a program.
That's correct. So would that be grounds for a student under borrower defense as well, as if they decided they didn't want to go that route, that they didn't like the way we were
So
doing
could
the
they
teach-out?
do a borrower defense claim if they don't like the teach-out?
Yes, right.
So I would say that's not substantial misrepresentation. You're giving them an option for a teach-out. We're not requiring them to take it. So I'm failing to see where that would be misrepresentation.
Okay, thank you.
Thank you. Thank you all for coming. I hope that you enjoy the rest of your day and the rest of the conference. As I mentioned, I have another session in here at 11:40. I'd love to have you join me again. That is a regulatory update on accreditation. So you're welcome to come for that presentation. We are also repeating borrower defense, and we are repeating professional judgment tomorrow as well. So happy to see you at any of those sessions that you'd like to attend. Enjoy the rest of your day.